Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we're going to talk about artificial intelligence systems, or AI for short. We will explore what these are, how do or could they potentially affect our criminal justice system, and whether any action has been taken globally or locally to regulate them. So, what are AI systems? An AI system is a system that receives machine and human-based data and inputs, infers how to achieve a given set of human-defined objectives, and generates outputs in the form of predictions, recommendations, or decisions which influence the environments it interacts with. Just in case you're asking yourself, no, you are not in the wrong channel. The use of AI systems has not spared any platform, and the criminal justice system is no exception. For example, a London barrister's chambers is said to have reviewed over 10,000 documents for a high-profile murder investigation with the assistance of an AI platform. Luminance claim by deploying a unique blend of supervised and unsupervised machines learning algorithms to have provided the 20-person team with an immediate and graphic visualization of the entire dataset, allowing the lawyers to quickly and easily find crucial documents such as evidence, unused material, correspondence, and media evidence. This was further enhanced, says Luminance, by filtering functions enabling the team to cut through irrelevant data and record, whilst also ensuring that no stone was left unturned. Truly impressive. But what happens when similar methods are used for the purpose of detecting and even predicting crime? Some may still describe the moving Minority Report starring Tom Cruise as science fiction. However, the usage of data, algorithms, and artificial intelligence systems to predict if certain people are at risk of committing crime in the future is being increasingly used by police force and law enforcement agencies, as well as criminal justice authorities across Europe. For those who are not familiar, and by way of background, the Minority Report movie was released in 2002. In short, in 2054, where the movie is set, Washington, D.C. embraces a new crime-fighting technology known as pre-crime, which uses the ability of three psychic individuals called precogs, human with precognitive abilities, to predict and prevent crimes before they occur and to identify and apprehend the individuals involved. However, when the precogs predicts that the chief of the pre-crime team himself will commit a murder in the next 36 hours, the integrity of the system is called into question. The chief discovers a flaw in the precog's vision and suspects that the system can be manipulated. As he delves deeper into the conspiracy, he learns that the creator of pre-crime has been using the system for his own personal gain, and afraid that the chief will expose him, sets out to frame it for a murder he did not commit. Eventually, the chief confronts the creator of pre-crime, who confesses to his crime but justifies them as a necessary sacrifice for the greater good. Eventually, the system is shut down and pre-crime is abolished. Minority Report explores themes such as free will, determinism, and the ethical implication of technology and predictive policing. It raises questions about the balance between security and personal liberty and the potential dangers of a society that value prevention over due process. In terms of analogy with AI policing, Minority Report raises important ethical questions and concerns about the potential misuse and abuse of advanced predictive technologies in law enforcement. AI systems are being increasingly utilized by police department for various tasks, including predictive policing, facial recognition, and crime pattern analysis. These technologies have the potential to assist law enforcement agencies in identifying and preventing crime. However, there are concerns about the accuracy, fairness, and potential biases embedded in these systems. Just like the precog in Minority Report could have false visions and manipulations, AI system can also generate false positive and false negative, leading to wrongful arrests as well as overlooking actual crimes. Additionally, there are concerns about the privacy and civil liberties of individuals when extensive surveillance and data collections are involved. The analogy with AI policing is that we must be cautious about implementing such technologies without proper oversight and safeguards. There is a need to ensure transparency, accountability, and adherence to ethical principles when using AI in law enforcement. Human judgment and intervention should always be involved in making critical decisions, and the potential biases of technology must be addressed and mitigated. Furthermore, discussion about AI policing should include input from diverse perspectives to avoid exacerbating existing societal bias and to ensure that the systems are fair and just. It is critical to strike a balance between utilizing the benefits of AI in law enforcement while upholding individual rights, privacy, and the presumption of innocence. Are these concerns being addressed by authorities globally and locally? And if so, how? Well, before looking into it, if you are finding this video useful, please hit the like button and consider subscribing so that we can reach a wider audience and continue bringing to your attention issues that affect and inform our criminal justice system. Thank you. So, how authorities have responded to the risk associated to AI policing? On 14th of June 2023, the European Parliament approved its negotiating position on the proposed Artificial Intelligence Act with the 499 votes in favour, 28 against and 93 abstentions. They voted to actually ban the use of predictive policing and criminal prediction system. The ban is the first of its kind in Europe and the first major ban on such systems worldwide. The rules would ensure that AI developed and used in Europe is fully in line with the EU rights and values, including human oversight, safety, privacy, transparency, non-discrimination, and social and environmental well-being. The rules follow a risk-based approach and establish obligations for providers and those deploying AI systems depending on the level of risk the AI can generate. The most harmful systems will be banned. The high risk will be subject to strict legal requirements, and the low risk will be left unregulated. AI systems with an unacceptable level of risk to people's safety would therefore be prohibited, such as those used for social scoring, classifying people based on their social behavior or personal characteristics. MEPs expanded the list to include bans on intrusive and discriminatory uses of AI, such as real-time remote biometric identification system in public accessible spaces, post-remote biometric identification system, with the only exception of law enforcement for the prosecution of serious crimes and only after judicial authorization, biometric characterization system using sensitive characteristics, for example, gender, race, ethnicity, citizenship status, religion, political orientation, predictive policing systems based on profiling, location, or past criminal behavior, and emotion recognition systems in law enforcement, border management, the workspace, and educational institutions. And untargeted scraping of facial images from the internet or CCTV footage to create facial recognition database violating human rights and right to privacy. Obligations for general purpose of AI also has been provided. Providers of foundation models, which is a new fast-evolving development in the field of AI, would have to assess and mitigate possible risks to health, safety, fundamental rights, the environment, democracy, and the rule of law, and register their models in the EU database before their release on the EU market. Generative AI systems based on such models like ChatGPT would have to comply with transparency requirements, disclosing that the content was AI generated, also helping distinguish so-called deepfake images from real ones, and ensure safeguards against generating illegal content. Detailed summary of the copyright data used for their training would also have to be made publicly available. But the MEPs have gone further, supporting innovation and protecting citizens' rights. To boost AI innovation and support SMEs, MEPs added exemptions for research activities and AI components provided under open source licenses. The new law promotes so-called regulatory sandboxes or real-life environments established by public authorities to test AI before it is deployed. And finally, and very importantly, MEPs want to boost citizens' rights to file complaints about AI systems and receive explanations of decisions based on high-risk AI systems that significantly impact their fundamental rights. MEPs also reformed the role of the EU AI Office, which would be tasked with monitoring how the AI rulebook is implemented. How and if this will affect the UK is still to be seen. The UK's approach to AI was revealed by the government in March 2023, as set out in a white paper entitled A Pro-Innovation Approach to AI Regulation. In general terms, it seems to be in line with the EU approach. It states, Our approach to AI regulation will be proportionate, balancing real risk against the opportunities and benefits that AI can generate. We will maintain an effective balance as we implement the framework by focusing on the context and outcome of AI. This is also replicated in the list of objectives in the white paper, with one of them said to be to increase public trust in AI by addressing risks and protecting our fundamental values. Though it does not go as far as to consider banning some identified high-risk practices, it states our assessment of cross-cutting AI risk identified a range of high-level risk that our framework will seek to prioritize and mitigate with proportionate interventions. Without government action, AI could cause and amplify discrimination that results in, for example, unfairness in the justice system. Similarly, without regulatory oversight, AI technologies could pose risks to our privacy and human dignity, potentially harming our fundamental liberties. Our regulatory interventions, say the white paper, will ensure that AI does not cause harm at a societal level, threatening democracy or UK values. However, the white paper also states we will not put these principles on a statutory footing initially. New, rigid and onerous legislative requirements on business could hold back AI innovation and reduce our ability to respond quickly and in a proportionate way to future technological advances. Instead, the principles would be issued on a non-statutory basis and implemented by existing regulators. During the initial period of implementation, says the white paper, we will continue to collaborate with regulators to identify any barriers to the proportionate application of the principles and evaluate whether the non-statutory framework is having the desired effect. Following this initial period of implementation, the white paper says, and when parliamentary time allows, we anticipate introducing a statutory duty on regulators requiring them to have due regard to the principles. Some critics have claimed that this delay in introducing a statutory framework will create gaps and that a more urgent action is required given the fast pace in which these practices are developing. And we agree. And what is your position? Let us know in the comments below. Also, like this video if you found it useful and consider subscribing if you have not done so already to help us grow this channel, and of course also join our networking hub at spokeninjustice.net to have your say as to the future of content of this channel. Join us again next week. We look forward to usher you as we sit and rise in this unique trial.